Good afternoon, everybody. My name is Jacek Stramski, and it is my pleasure to introduce you to navigating the lobbying labyrinth, ethics for lobbyists and public servants today. Before we get started with our presentation, I would like to take a moment to acknowledge our sponsors who made the CLE possible. The first is the Government Advocacy Committee and our chair, Kelly Kibbe-Smith, who would like to say a few words.
Hi, guys. Thank you so much for joining us today. Thank you, first off, to Jacek for, he's giving us the credit here, but he has organized this entire thing. To brag on him for a minute, he is the Government Advocacy Committee's Director of Membership, and we are just thrilled to have him. This is not a formal meeting of our committee, but we do have those. We're going to have one in the spring after Sine Die, hopefully in the Capitol, and then we've got the Florida Bar Annual Convention meeting, too. We're going to meet on that Wednesday in Orlando. The main purpose of our committee is to have a place in the bar for lawyer lobbyists and legislative staff, people who are involved with advocating in the process, both state and local government, because there wasn't really a great place for us in the bar before that. So we do have some overlap with the government lawyer section. We're very happy about that, but ultimately it is a more specialized subsect. If you're interested in joining our committee, we would love to have you. You can do that during the next committee selection process, actually. So you're going to have to, unfortunately, wait until December 1st. And then December 1st through January 15th in your bar profile, you'd be able to go in and select our committee. We would love to have you, so please don't hesitate to do that. In the meantime, feel free to reach out to us if you have any questions, and we'll continue to focus on providing good CLEs for you. But we're looking forward to today, and thank you so much, Jacek, for putting this together for us.
Thank you, Kelly. And the second organization is the Government Lawyers Section, chaired by Russell Kent. So the Government Lawyers Section is the section within the Florida Bar that represents all government lawyers and other practitioners who are interested in this area. I would strongly encourage anybody who's interested in getting involved in bar work or staying on top of things that are relevant to government lawyers to take a look at the Government Lawyers Section's website at flgovlawyer.org. There are all sorts of benefits like free CLEs, discounted memberships for various other sections that we partner with. So I would strongly recommend you check that out if you may be interested in it. And of course, I do have to thank Rick Kortenmensch, who's the Deputy General Counsel of the Florida Bar, without whom we wouldn't be here right now. He is providing us stellar service in recording the CLE. So thank you, Rick, so much for making that possible.
You're welcome. I'm going to, as I was mentioning earlier, when this is completed, we're going to be able to pull it together as a video that we will be able to place on the Government Advocacy Committee webpage, the Government Lawyers Section webpage, and on Legal Fuel. So it will be available to anybody who wants to watch it for free CLE credit.
Thank you. And with that, I would just like to remind everyone who is on, again, that this is being recorded, so please mute your conversations so you don't waive any attorney-client privilege or any other matters. And you may want to also turn off your cameras for the length of the presentation. So again, please mute your screens, and we'll appreciate that. Thank you so much. So with that, it's my absolute privilege to introduce our speakers today. Our second speaker is going to be Carolyn Klenke, who currently serves as the Executive Director of the Florida Ethics Institute. Caroline literally wrote the book on ethics in Florida. It's aptly titled the Florida Ethics Handbook. It's a wonderful resource for anybody who's interested in this area, who works in this space. So please check it out. Caroline previously served as the General Counsel and Deputy Executive Director of the Florida Commission on Ethics. She was, before that, the Chief Ethics Officer at the Public Service Commission. She lectures extensively on ethics in Florida. You may have heard her on NPR if you're a listener like I am, discussing Florida ethics issues here in the state. She has been recognized by the Florida Association of Counties in 2023 with the Ethics in Government Award. She has many more accolades that we just don't have time to list here today, but I'm thrilled that she was willing to share her knowledge with us. So thank you, Caroline, for joining us today. She'll be speaking about lobbyist registration, compensation reporting, and recent changes to the Florida Ethics Code. Our first speaker today will be Joy Stubbs, who I am absolutely grateful to call a colleague. She is the Chief Ethics Officer at the Florida Department of Revenue, where for a number of years she has really helped foster a spirit of being proactive in the field of ethics and really engaging with this area. And she's kept a lot of folks I know in our agency on the straight and narrow, or I guess out of potential inadvertent pitfalls while we're navigating the lobbying labyrinth, from entry-level folks all the way to the executive level in our agency. So she's a tremendous resource. Joy has previously served as an assistant attorney general here in Florida. She has served as the assistant general counsel for the Commission on Offender Review, which is also, or was known as, the Parole Commission. And previously, she served as a central staff attorney with the Florida Supreme Court. So with that, I will be turning it over to Joy, who will be discussing today gifts, bribes, and expenditures. Joy, the floor is yours.
Okay. Thanks, Jacek. All right, so welcome to a tour of the Labyrinth. The Labyrinth is a good description of the work in handling a question about gifts and things of value offered to public servant. You progress through several stages of inquiry and examine various facts. As I said, Labyrinth is a good description of the work involved in handling a question about gifts or things of value offered to public servants. You progress through several stages of inquiry and examine various facts. Before we go into the Labyrinth, let's recognize the foundation of Article 2, Section 8 of the Florida Constitution. At some point in your career, you'll have heard a public office is a public trust. The people shall have the right to secure and sustain that trust against abuse. The Constitution does this by mandating a code of ethics, establishing an independent commission, and creating certain restrictions and disclosures at the constitutional level. The Code of Ethics for Public Officers and Employees was adopted into state law under Chapter 112. The Code of Ethics ensures that public servants conduct themselves independently and impartially and not for private gain. Here we take a moment to recognize the Commission on Ethics. The Commission is the guardian of the state's ethics code, and in addition to investigating complaints, the Commission works to assist public servants in avoiding ethics violations. The Commission website has a search engine with good capabilities to access advisory opinions. And it staffs its office with knowledgeable attorneys who answer questions during business hours. You can call them and probably get the answer to most of your questions. The Commission complaint process is set forth here, and I'm including it for educational purposes, but I'm going to pass by it to focus mainly on preventing violations. Section 112.3132 is what we'll start with. This is what prohibits public servants from soliciting or accepting anything of value based upon any understanding that their vote, official action, judgment would be influenced. Now that's quite a few words, which I'll shorten to 3. Quid pro quo. I would even note that in one recent case, a commissioner described a particular violation as flat out bribe. This statute governs all public employees from top to the front lines to the executive suite. And anything of value can be a lot of things as seen by this slide. It's also vital to identify the donor and their connection to the public agency and the employee's role. Who are we talking about? A vendor, an advocate, a citizen in a participant in a program. It's also important to examine what's the employee that could be of interest to the donor. Okay, so that's how you put the concepts together. Public employees often boil this down to the mantra, we don't take gifts for doing our jobs. This gets tested sometimes when corporate vendors send holiday gift baskets or an agency program participant brings in some homemade baked goods, maybe because a staff member was really helpful or listened to them in solving a problem. but public agencies have internal codes directing the refusal and return or disposal of these things. I'm going to go on to unauthorized compensation, which I'll try to explain is not actually a duplicate of the first one, although they're very similar and sometimes they're spoken of together by the commission. And it, like 112.3132, affects all public employees.
Joy, just one moment. Will you, we've had a request for you to put it in slideshow mode. Would you go up to the words slideshow at the top of your screen and start from the current slide?
Is that it?
Yes.
Okay.
This is started from the beginning, so you're going to go through to subsection 4 slide and then proceed from there.
Okay. Let's see. So
you'll just advance the slides.
Yeah, there I see what it is. Okay.
Good job.
We did practice, guys. And all right. So here we're on for subsection 4. You guys are great. And okay, so it affects not only the public employee, but their spouses, their minor children may not accept compensation, payment, or thing of value when they know or with reasonable care should know that it is being given to influence their official action. For example, trying to think of how this could be a way that you could visualize this. Imagine someone who appears before the public employee on some matter that the public employee has responsibility over. And a special business opportunity or patronage to that public employee's spouse who owns a private business also emerges. Okay, that's, as you can see, again, it's important to recognize the donor identity and the connection to the employee's agency role. And then what you're looking at is, do the circumstances indicate that the donor could be benefited by the employee's actions? Okay. And this isn't something that the public employee can ignore. Section 112.3134 puts the burden on the employee to recognize when a seemingly separate donor action is undertaken to influence.
Hey, Joy, we can always just send these slides out afterwards. If anybody needs them, they can request them from us. We don't need to
make it.
I can see right on mine. Okay. Yeah, we don't need to make it too complicated. Also, if you are not on mute, please double check that you are on mute because we can hear some fun conversation. Thanks.
Okay. All right. I want to. My next slide that is up is about. It's called rights, and this is what we're talking about. Up until this point, we've been talking about laws that apply to all public employees. We're now moving on to law which governs reporting individuals and procurement employees, often referred to collectively as rights. Reporting individuals are individuals required to file financial disclosure pursuant to under Form 1 and Form 6. Procurement employees is an employee who has in the last year participated in the procurement of contractual services or commodities in excess or expected to exceed $10,000. So reporting individuals and procurement employees are governed by 112.3132, 4, and additional laws. Thus, when working with a gift or thing of value question, it's important to know if the public servant has a designation of reporting individual or procurement employee. All right, so gift law is under gifts laws, kind of what we call it, in part to help distinguish it from some of the other laws, and it is under 112.3148. Its provisions are applicable to rights. specific donors implicate the prohibitions, and they are vendors doing business with the RIPES agency, political committees, lobbyists who have done business with lobbyists who have lobbied the RIPES or their agency in the past 12 months, and the partners, firms, employers, and principals of such lobbyists. And to simplify this for the purposes of this discussion, I'm going to just call them prohibited donors. The first thing to know is that a RIPE may not solicit any gift from these prohibited donors, right? And there is no value threshold here. RIPEs may not ask a prohibited donor for a gift of any value. Second, RIPEs must not accept directly or indirectly a gift worth more than $100 from a prohibited donor. There's also a complementary provision in the statute which prohibits a prohibited donor from giving a RIPE a prohibited gift of over $100. Okay, so, and then there's another provision which I'm going to talk about, which sometimes RIPEs aren't aware, or they don't, they need, it helps to give reminders of it, is that a RIPE must report a permissible gift of more than $100. And that's under 112.3148. And this is reported on the Commission's Form 9 quarterly gift disclosure for gifts over 100. So what this means is if a RIPE receives a gift worth more than $100 from someone who is not a prohibited giver, the RIPE must report the gift. An example of this would be, say the RIPE had a college roommate who lives in Seattle, has no business with the state, but the college roommate, they're going to get back together, and the college roommate bought the RIPE fabulous, hard to get concert tickets. That would be something that, even though there's no connection with that that donor's position in their job, the RIPE would still have to report it. But what about gifts from family? RIPEs do not have to report gifts from family and may accept gifts from family if a family member meets the definition of under 112.312.21 Florida statutes. All right, so this is a specific precise definition of vendors and lobbyists for purposes of 112.3148 and 112.3149, which I'll say for a minute, gift and honoraria law is covered by 112.3149. I actually am not going to go into it today to save time, but if you're taking notes, be aware that that is out there, and that the Commission has helpful opinions, advisory opinions on speaking and presenting for RIPEs. Okay. And another quick moment about lobbyists and vendors. The definition for lobbyist for purposes of gift law is actually going to be different than the one that you'll see in a few slides for expenditure ban. And then here is the definition for vendor. I find that there's a good resource, would include an agency's contract department to find about who vendors are. And then I also utilize Department of Financial Services, has a searchable website called FACTS, which is an acronym for Florida Accounting Contract Tracking System for state agencies. Okay, donor reporting. Remember how I talked to you about how prohibited donors may not give a gift worth over $100 to a RIPE? Well, in the case of gifts under $100, they must be reported by a prohibited donor when it has a value in excess of $25, but not in excess of $100. And this is filed on a Form 30 the donor's quarterly gift disclosure form. And then one of the interesting things about this is that when a gift is made which requires the filing of a report under this subsection, the donor must notify the intended recipient at the same time that the gift is made, that they will be reporting the gift. All right, so do you know a gift when you see it? A gift can be anything you get for which you do not give equal or greater consideration within 90 days. The definition of a gift is very broad, as this slide demonstrates. There are, of course, things that do not constitute a gift, such as salary or private employment, campaign contributions, awards and recognition of service, and gifts when there is a government officer or employee organization. I would add on this slide, even though I don't have it listed out, is that knowing the value of a gift is very important when working with these statutes. Valuation is controlled by section 112.31487 and rule 3413.50 Florida Administrative Code. Generally, gifts are to be valued according to the actual cost to the donor, but the statute and the rules also provide for specific valuation for specific types of gifts and specific gift circumstances. This is another intricacy of the labyrinth, and we're not quite done. But I want you to understand that when you're thinking about valuing a gift, to check out those statutes, because the way they're valued isn't always intuitive, and they may actually be controlled by a specific rule. Okay. Indirect gift is where a gift by prohibited donor is provided to a person other than ripe, but the benefit of the gift is ultimately received by the ripe. Okay. The Commission has promulgated 341331 of the Florida Administrative Code, which contains an 8-factor test that helps determine whether something is an indirect gift or not. However, per the rule itself, the Commission is not limited to just the 8 factors in the test. So what kind of factors are we talking about? I'll give you a handful. These factors are things like the existence of or non-existence of any relationship between the donor and the third person, and the nature of that relationship, whether same or similar gifts are provided to other persons having the same relationship to the donor as the third person. Also, I find this one's pretty important. What kind of independence does the third person have in deciding whether the ripe receives the gift? So you're basically looking to make sure that that this is truly from the third party that is not a prohibited giver, that this is a genuine, authentic gift there, and not, as the title says, an indirect gift. Okay. I would encourage any practitioner to read the statutes, ask questions to get at the facts. Sometimes this is literally what you call following the money, and search advisory opinions for applications, and consider the Commission as a resource for guidance. Okay, the expenditure ban. This is another layer of law. So now we've already walked through two sets of layers. Here's a third one, and this affects only reporting individuals. This statute provides that no executive branch or legislative, lobbyist, or principal, right, those are the entities that are employing the lobbyists, shall make directly or indirectly, and no reporting individual shall knowingly accept directly or indirectly any expenditure for purposes of lobbying. Okay, remember how I said there would be a different definition for lobbyist? Here we are talking about executive branch lobbyists, or in the case of folks in the legislative branch lobbyists. And they are someone who is paid to lobby, or someone who is principally employed by governmental affairs to lobby on behalf of that person or the entity. You can find out who is an executive branch lobbyist or legislative branch lobbyist and their principals on the lobbyist registration page, which is floridalobbyist.gov. You can even download the directories onto your phone. And yes, I'm like that. I have that. An expenditure, which I have listed here, is payment, distribution, loan, advance, reimbursement, deposit, or anything of value. Probably you just need to remember anything of value made by a lobbyist or principal for the purposes of lobbying. Okay, so now step into the next level. What is, for purposes of expenditure ban, what is lobbying? Lobbying is seeking to influence an agency or an agency officer in a matter with respect to policy or procurement. And that's normally what kind of sounds like lobbying. But then there's a second piece, or attempting to obtain the goodwill of an agency official or employee, right? Goodwill is sometimes can be a challenging concept to explain to someone new to expenditure ban law. For example, this is probably the best example I can explain, and then try to shoot down how strict it is. If a government attorney in the executive branch meets up with their friend from law school, who happens to be an executive branch lobbyist, and they go out to lunch, the government attorney must pay full value for their meal so as not to incur a prohibited expenditure. It doesn't matter if the lobbyist is a childhood friend. It doesn't matter if they don't specifically lobby the government attorney's agency. Okay, that's another way it's different from gift law. Okay. And there's also no exemption for birthday gifts, get well gifts, etc. So this is the part where, I have to say yes, really, to people. It should be mentioned that expenditure law also will override gifts or honoraria law where they overlap. And I'll give you another good example. Remember how I talked to you about how in gifts law, there's a threshold of $100, accepting a gift of $100 from a prohibited donor. Under expenditure ban, there is no $100 threshold. It means any value, expenditure of even de minimis value are prohibited. And then don't forget that indirect expenditures are prohibited too. Florida Administrative Code 34-12-190 is the commission rule to determine whether something is an indirect expenditure, and it mirrors the one for gift law, which we've already touched on. In expenditure ban situations, there are some commission opinions which I would just basically describe as making a carve out for particular situations. For example, cellular plan discounts that are of widespread business promotion and do not target reporting individuals are not considered prohibited expenditures. There is a carve out for situations such as when a reporting individual receives compensation for serving on a board as a board member of an entity, and so long as that compensation is consistent with the same as other board members for that entity. There are opinions regarding information and informational gatherings, finding no value to the recipient where no admission fee to participants is charged and only oral or written information is provided. Read opinions on carve-outs and exceptions to the rules situations very carefully. There is more to know about expenditure ban law. Again, I would encourage any practitioner to get familiar with the lobbyist registration website. There may be some lobbyist principles out there that you would be surprised are actually lobbyist principles and therefore would trigger an expenditure ban question. I would ask questions to get at the facts, search advisory opinions for statutory applications, and remember that the commission is a resource for guidance. For those of you in the private sector, remember expenditure ban applies to lobbyists and principals too. It prohibits the making of a prohibited expenditure. It's not hard to actually find out if an individual is a reporting individual. The Commission on Ethics has what they've recently unveiled as their new financial disclosure management system, EFDMS, which lists those who file Form 1 and Form 6. And you can also just ask the person. They're very aware of their status, and in doing so, you'll actually demonstrate a commitment to compliance. Finally, this presentation has been confined to the specific portions of the Code of Ethics. I would note that many agencies and some local governments have their own internal codes, which may be more restrictive. This means you may have to traverse the labyrinth again and contemplate the corners and angles of gift and value questions again. I again want to really, I'm going to hand it over to Caroline. I'm very thankful for your patience and Yasek's, who was right on hand to help me. And thank you for giving me your time today.
I want to thank Joy Stubbs for her excellent presentation, and I'm going to take it over from here. Okay, so I'm going to be covering the bifurcated universe of executive branch and legislative branch regulation of lobbying. And this bifurcated universe concept is replete within this regulatory scheme. And it begins at the highest level, which is the regulation of lobbyist registration and compensation reporting is essentially bifurcated between the executive branch, which is governed by portions of the Code of Ethics contained in Part 3 of Chapter 112. And as you can see from this slide, statutes 112.3213 through 3217 cover the landscape. But the real meat of this menu is unquestionably in section 112.3215, which governs the registration and compensation reporting of lobbyists and lobbying firms, respectively. The Commission on Ethics has also adopted a very, very helpful rule chapter 34-12 of the Florida Administrative Code, which gets into the nuances of these terms, which are incredibly helpful, but also the regulatory scheme with respect to state lobbyists seeking to lobby executive branch agencies. Now, with respect to lobbyists seeking to lobby the legislative branch, that is also governed by Florida statutes, and in particular, sections 11.044 through 11.062. However, unquestionably, the meat of this menu is contained in section 11.045, wherein the lobbyist registration requirements regarding lobbyist registration and compensation reporting is set forth. Joint Rule 1 contains a wealth of information with respect to registration and compensation reporting requirements as well. The Florida Senate Rule 9 is incredibly helpful. It has really good examples of things constituting lobbying and how to navigate different factual scenarios. Rule 17 of the Florida House, this is the rule that requires registered lobbyists to electronically file a notice of appearance, identifying the matter specifically which they are pursuing and seek to lobby with respect to. The exact bill number has to be identified by those registered lobbyists. This appearance or notice requirement was added to the transparency requirements of legislative branch lobbying a few years ago. And it is set forth in Rule 17, and in particular 17-1 of the Florida House. Incredibly helpful. Beginning in 2015, the executive and legislative branch compensation reports filed by lobbyists were made subject to random annual audits, wherein 3% of the legislative lobbying firm compensation reports and 3% of the executive branch lobbyist compensation reports were selected for audit annually. The executive and legislative branches has JLAC, or the Joint Legislative Auditing Committee. They are the ones who undersee the annual audits, both the selection of lobbying firms to be audited, as well as the audits themselves. They have an incredibly helpful set of rules that are referred to by them as the guidelines for attestation of services relating to court-ordered lobbying firm compensation reports, which they refer to as the guidelines. The guidelines contain a wealth of helpful information for governmental lobbyists regarding how to properly report lobbying firm compensation. We're going to be talking about some of the common mistakes that are made and have been made manifest by virtue of these annual audits from 2015 until present, and some legislative changes that will impact the executive branch statute that were passed in 2023 and which impact these lobbying firm audits. So let's talk about the bifurcated universe in terms of application. Lobbyist registration and compensation reporting are the two spheres of regulation that are required on the state level. So lobbying registration applies to natural persons who meet the definition of lobbyist. As you can see from this slide, they fall into two different categories. Bifurcation continues. The universe of the definition of lobbyist, as Joy mentioned, is defined within these lobbyist statutes, Section 11.045 for the legislator and Section 112.3215 for executive branch lobbying. Lobbyist is defined to be two types of persons. A person who is retained pursuant to contract and provided compensation for lobbying. That's like a lawyer in private practice who engages in lobbying activities and is retained pursuant to a consulting agreement by a principal, a business entity or person seeking to retain a lobbyist for lobbying purposes. Or a lobbyist could also be a full-time employee of their one principal who receives a W-2 from that principal and is principally employed for governmental affairs, which the rules, for example, in Rule 34-12, that rule chapter, it goes on to further define this concept of principally employed for governmental affairs to mean that the individual's employee responsibilities to their employer have either the most significant or a very significant part of their responsibilities being overseeing these relationships with governmental officials and agencies. Lobbying, as Joy mentioned, can include both attempting to influence the official decision-making capacity of the legislative or executive branch, or to engender the goodwill of a public officer or employee thereof. The requirement to register is prospective in nature, meaning that it is required to occur. A lobbyist has to register with the state before engaging in any activities that constitute lobbying, either the legislative branch or the executive branch. And registration is due upon being retained to lobby on behalf of a principal. Lobbyist registration is primarily achieved through the electronic lobbyist registration and compensation reporting system located at floridalobbyist.gov. This system not only is a one-stop shop for the bifurcated universe, meaning that you can register to lobby the legislative branch through this portal, and you can register to lobby the executive branch through this same portal. But lobbyist registration for these different branches has to be completed separately. That's going to be important when it comes to compensation reporting as well. Lobbyist registrations are effective for a calendar year or until they are terminated, and they are renewable annually. The fees for registration are a little bit different for the legislative branch versus the executive branch. Having been the general counsel and a senior attorney with the Florida Commission on Ethics, I hope that we all appreciate what a bargain executive branch lobbying on the state level is, because, for example, at the time of registration, a lobbyist seeking to register to lobby the executive branch can select all executive branch agencies at no additional cost. And after paying the initial fee for registration, as well as $25 for each additional principal, if they say elected to identify only a few lobbying agencies, they can amend that at no extra cost. There are also exceptions to these fees set forth by law that you should be cognizant of. Lobbyist registration requires a lobbyist to provide certain information regarding whom they are representing and who they are, i.e. their name, business address, things of that ilk. They also have to receive separately during the registration process. And all of this is overseen by the lobbyist registration offices, which is housed within the Office of Legislative Services. They have incredibly helpful lobbyist registrars that are co-located at the Office of Legislative Services in the lobbyist registrar's office. And I can't tell you how they are doyens of knowledge and information. On a later slide, there we'll have their contact information. There's one for the executive branch and the legislative branch. They're incredibly helpful. The principal also has to authorize the representation via a separate authorization, and certain business relationships maintained with either executive branch agency employees or officials or legislators have to be disclosed during the registration process as well. Now, remember, our bifurcated universe of lobbyist regulation is lobbyist registration and lobbying firm compensation reports. But I want to put a fine point on the fact that compensation reporting applies to lobbying firms. Now, remember that lobbyists who are required to register fall into two different possible categories. Those retained pursuant to contract, which they refer to as contract lobbyists, colloquially, and those who are full-time employees of their employer. The first form, contract lobbyists, will associate with a lobbying firm during their registration, and that lobbying firm will be required to file quarterly compensation reports. But the latter type of lobbyist, a lobbyist who receives a W-2 from their one employer, is not going to associate with a lobbying firm during their registration, and that full-time employer of theirs, which is not a lobbying firm, will not have to file a compensation report. I want to put a fine point on this because the lobbyist audits annually identify that this is an area wherein mistakes occur, wherein well-intentioned lobbyists during the registration process will erroneously identify themselves when they are full-time employees of their one principal as having to file quarterly compensation reports. And I want to put a fine point on it. For example, in the legislative lobbying FAQs, question 18, it defines lobbying firms in that question and its response. This is on the floridalobbyist.gov website. And it specifies, quote, if you are an employee of your principal and receive a W-2, then you are not a lobbying firm. And it further provides Florida state agencies are not considered lobbying firms and thus are not required to file compensation reports. Similarly, executive branch FAQs on the lobbyist compensation reporting system has a question in question 16 that makes a similarly fine point. regarding who is required to file compensation reports. And they say, for example, a lobbyist who is a full-time employee of the principal, i.e. they receive a W-2 rather than a 1099, is not a lobbying firm and should not file quarterly compensation reports unless the lobbyist's sole principal employer derives compensation from principals for lobbying, end quote. I mention this because the issue is during JLAC's annual lobbying compensation report audits, every year they identify lobbying firms that have erroneously been associated with a lobbyist who is a full-time employer of their full-time employee of their one principal, and they were never required to file compensation reports, and they were doing so in an abundance of caution, which is not required. So JLAC often in its annual audits will select 3% and will have some backup lobbying firms, and each year you see them having to pull from that additional list so that they can, and they will tell the lobbyist in that scenario that they've erroneously identified themselves as being associated with a lobbying firm. But when a lobbying firm has correctly associated with lobbyists, they are required to file compensation reports 4 times a year. Those times are set forth by law within the statutes. And the information that is required to be disclosed is set forth by law within the statute. It is designed to elicit transparency from lobbying firms regarding who their lobbyists are and who their principals are who have retained those lobbyists and what they pay. This is facilitated by law by requiring the revelation of total compensation provided or owed to the lobbying firm from all principals for that particular calendar quarter, as well as the total compensation provided or owed to the lobbying firm from each principal represented. There's also specific statutory requirements designed to engender the transparency regarding lobbying work that is provided as a result of a subcontract, that subcontracted work, and the compensation associated therewith also has to be revealed in these compensation reports. And I want to stress in guiding principles that lobbying firm compensation has to be reported using the accrual basis of accounting and not the cash method of accounting. Now, we see the JLAC audits annually of compensation reports, and this is a very common mistake. Mistakes that are identified in the reports of JLAC's accounting firms they hire are identified as exceptions. Exceptions are mistakes that are contained in compensation reports, and this is a big one. Not using the accrual basis of accounting. Okay, when you accidentally use the cash method of accounting, this results in reporting lobbying compensation in the wrong quarter, and that is a mistake. Another common mistake that we see in these audits is lobbying firms double reporting. And there are 2 types of double reporting. For example, a lobbying firm has several lobbyists. Those lobbyists are retained by a principal or principals pursuant to a consulting agreement. The first form of double accounting or double reporting that compensation is when a consulting agreement has compensation provided to the lobbyist for some activities that involve lobbying, some activities that do not involve lobbying. The lobbying firm should not disclose all of the money that the contract provides. That is double reporting. You're to report only compensation provided for lobbying. Similarly, a consulting agreement will have and retain a lobbyist for the purposes of lobbying the legislative branch, and they will pay them for that. and they will pay them for lobbying the executive branch. And double reporting erroneously can occur when you just report all of the money in a contract that contemplates executive and legislative branch lobbying. If you just disclose all of it, that can very easily be characterized as an exception or a erroneously reported compensation. JLAC, the Joint Legislative Auditing Committee, asks that lobbying firms use a good faith, rationally based, contemporaneously documented allocation of compensation so that they report quarterly their compensation provided with exactitude. At the bottom of this slide is perhaps one of the most important guiding principles. When in doubt, call the Lobbyist Registration Office. They have lobbyist registrars who work the phones every single workday, and I cannot tell you how helpful it is. You can call the Lobbyist Registration Office and ask to speak with either the legislative branch registrar or the executive branch registrar. They are co-located at that facility. That is their phone number, area code 850-922-4990, or you can send them a request for assistance via email, and that is their helpline for their email. So helpful. They will give you rapid fire answers to any compensation reporting or registration question you might have. They are incredibly invaluable. As you can imagine, it is important to file timely these quarterly reports when you are a lobbying firm associated with these lobbying firm reports have automatic fines that if you blow past a deadline that is set forth by law, $50 a day per report will begin to accrue. And it is imperative that you are cognizant of those fines because they can really add up. They can be appealed on the basis of unusual circumstances that prevented the timely filing of that report. And there is a one-time waiver that applies automatically. Let's talk about, as we mentioned, we're going to use the accrual method of accounting. We're not going to double report. We are not going to have any exceptions in our audit reports if we are selected via the random selection process. But I have some good news at the very end of our lecture to leave you with, because there has been some legislative movement in 2023 through the Senate's passage of Senate Bill 774, which occurred last year. Prior to 2023, Senate Bill 774 did a lot of things in terms of amending different provisions of the Code of Ethics for public officers and employees. Prior to 2023, the primary statute, section 112.3215, contained a subsection, so section 8C, that required the Commission on Ethics to automatically self-initiate an investigation annually when they received lobbying reports that had exceptions in them that identified a possible violation. And a lot of those exceptions were just inadvertent accounting errors, like using the accrual basis of accounting and thereby reporting compensation in the wrong quarter. And this resulted in a lot of probable cause findings associated with these investigations. But last year, Senate Bill 774 amended this subsection of the statute. And now it amended it so that it included 2 mens rea requirements with regard to these investigations. And now the statute reads that the commission will only investigate a lobbying firm when it receives a report or complaint that indicates that the firm has intentionally failed to disclose a material fact or has knowingly submitted false information. These mens rea requirements will cut down enormously on the commission's instituting of these investigations and concomitant probable cause determinations, because it is very, very rare for any form of intentionality to be identified in these accounting errors. The commission was also authorized via a new subsection of subsection 8, I believe it's D, 8D, that added language that affords the commission with additional authority to dismiss a complaint involving an audit investigation if it determines that the public interest is not served by proceeding further. So this will give them additional authority with regard to equitable resolutions of inadvertent errors identified in executive branch compensation reports as a result of an audit. So this is good news for lobbying firms, but the audits will still annually occur. And I want individuals who are subject to these regulatory schemes to always look before they leap and call the lobbyist registrar's office, because they are an absolute wealth of knowledge and information, and they're all super users as well. So they can see your screens if you ever run into anything that you are having trouble with regard to registration, either with regard to the legislative branch or executive branch or lobbying compensation reporting. That is my time for today. I want to thank you all. This is my contact information associated with the Florida Ethics Institute, the greatest nonprofit entity in Florida. And we, as the moderator mentioned, publish the Florida Ethics Handbook that goes into and analyzes every year the current regulations with respect to executive branch lobbying governed by and regulated by the Florida Commission on Ethics.
Thank you, Caroline. Thank you, Joy, for those fantastic presentations. I don't see any questions in the group chat. You do see the course number there. It is, again, 8294. So make sure to make a note of that. Let's see here. Yeah, we have thank yous. If there are no questions, folks, you do have the contact information for the speakers. I'll take this opportunity to volunteer them to be available to answer your questions and any follow-up you may have. It's great to see so many participants here and listeners. Thank you again for joining us, and that'll conclude our presentation for today.